financing, finance, mortgage, assurance, funeral care sous WSRF 1580 AM et 99.5 FM avec Kathleen Barrow. Nous là pour connecter avec toutes les ressources financières qui peuvent grandir. Pendant saison fête là, prend avantage sous liquidation fait année que Caballero Rivera cimetière Miami-Dade pour yoto limité économiser 20% sur espace cimetière ou bien mausolée dans Southern Memorial, Woodland West et Dade North. Et puis dans Fairway Memorial, wap joint 20% rabais sur espace TA et 10% rabais sur mausolée. Li pas facile pour planifier d'avance, mais li pas impossible tout. Gele Kounia, Kathleen Barrow dans 786 253 0211 786 253 0211 pour plus d'informations. Bien coup de prendre devant parce que avantage ça a fini 31 décembre 2024. Caballero Rivera là pour aider familles à planifier avec soin et économiser l'argent.
Nous même pas haïtiens, les nous fin grandi ti moun nou yo, nous ba yo éducation, yo joine bon job, yo vinn fonder famille yo. Qui ça qui ka arrive dans vieux jour yo? Ti moun nou yo a payer bill pa yo, petit yo pral l'école, est-ce qu'on déjà préparé enterrement? Pas quitter ti moun nou yo nan problème. Relé Kathleen Barrow dans 786 253 0211 pour ka aido préparer zafè enterrement. Pas quitter petit ou yo ap chercher l'argent dans mes amis. Relé Kathleen Barrow dans 786 253 0211 786 253 0211.
Each day, the cost of living is increasing. It is the same as funeral and cemetery costs. Pre-plan your arrangements today and save your family the stress of finding the money later. Finance your plan up to 7 years with low down payments and affordable monthly payments. To set up your appointment, call Kathleen Barrow at 786-253-0211. 786-253-0211. Bonjour tout le monde. Bonsoir. What am I talking about? It's like almost 7 o'clock and it's dark outside. So today we have a very, very special guest again. I think he's one of like my favorite guests. I hope none of the other guests are listening, but you really are one of my favorite guests. Like I really enjoy having you. So Jason Neufeld is an estate planning or an elder law attorney, and he was here in October, and he gave a very insightful show. He actually was here before we had that crazy monsoon tsunami.
Right.
Before he did the show before that whole storm came.
Yeah.
So now he's back to go into more detail about estate planning. And welcome to the show, Jason. Thank you so much.
Oh, my pleasure to be here. I'm glad we're able to do this again. Thank you for inviting me.
Absolutely. So I only have you for 27 minutes because I talk so much. So now we're going to do a more in-depth conversation about estate planning, guys. I really hope you're listening. I know some of you guys I chatted with are in the process of doing that before you guys get your pre-need. So guys, if you need an estate planning attorney, you have one here, and he's an amazing good one. So let's get into it. So Jason, how can individuals structure trusts to minimize tax liabilities and protect beneficiaries from creditors?
Yeah, so that is a great question. So first, I think it's really important to know that most people do not have to worry about estate taxes. Florida does not have any state estate tax, so you're not going to pay anything on behalf of the state of or to the state of Florida. The U.S. government does, but it's only once you have, I don't remember the exact number, but it's over $13 million. So most people should not be worried about estate tax planning. What they should be worried about is really probate avoidance. They're worried about creditor protection, and they're worried about really what is the most efficient way to get assets to the next generation or wherever it is they want it to go upon their passing and not have to go to court in order to accomplish that. So as far as protecting against creditors, we have to now talk about whether it's the person preparing the trust who's concerned about creditors. If so, then we're talking about an irrevocable trust. Or are they concerned about the next generation, like their kids, protecting that next generation from their potential creditors, or maybe getting divorced, or if they have a gambling problem or an addiction problem, right? How do we get them assets where it's not going to be threatened by some external third party? So the issue is with really all asset protection is control. So, Kattt, if you're my client and you come to me and say, I want to make sure that my assets are not subject to my creditors, meaning Katt's creditors, then we would be talking about an irrevocable trust. But in that situation, there would be one person who could not have direct control over the assets, and that would be you, right? Because if you have control over it, then a judge can order you to pay a creditor. If someone else, like another trustee, someone you know, who might have your best interest at heart, can be in control of these assets, now we can structure the trust in a way where it's not subject to your creditors.
Nice.
If you're not so concerned about your creditors, and we're more concerned about your children, for example, then we might want to use a revocable living trust, which is probably the most common estate planning tool, where we can structure that in a way where, again, it's all about control. So let's say, for example, let's assume you have 2 children. And one of them we have really no concerns about. They have a good partner who we're not concerned about filing for a divorce. They are responsible and they have a job and they don't have creditor issues. And then we have another child who does not fall into one of those categories, right? We don't like who that person chose as their spouse, and we're worried about them taking half the money, or they have a creditor issue, or they have a spending problem, a gambling problem, whatever the case might be. So with these 2 children, we have the responsible children and the irresponsible child. We may want to, for the irresponsible child, have your assets, 50% of your assets, go into, only after you pass away, go into a separate trust for their benefit that's controlled by the more responsible child. Now, it would be clear, the benefit of the trust is for the irresponsible child. It can only be used to pay for things that the irresponsible child needs, but the responsible child would be the one ultimately in charge of making those distributions. So in that way, we can still not have to disinherit somebody, not just give everything to the responsible child and hope for the best. We can still make sure that our assets go where we want it to go, but in a way that's a little bit more protected.
Wow, that's interesting.
Yeah.
Man. Couldn't that like cause some sort of conflict between the siblings?
So we have to trust that it's going to be all right. And there's protections we can build in where if the one that we believe to be responsible starts to act irresponsibly, there's a way we can kind of kick them out and bring somebody else in. But ultimately, I think you're right. We want to make sure that we'd like to avoid having to go through that process if we can, and we'd rather have the right people in place to begin with who are not going to cause those problems.
Okay, good.
I agree, yes.
Good. Okay. What are the implications of not updating your wills or trusts after major life events like marriage, divorce, or birth of a child?
That's a great question. So let's talk about divorce. That's a big one. So what a lot of people don't realize is there could be whether you like it or not, there could be a change to your estate plan and incapacity planning when you file for divorce, and then a different plan, a different change after the divorce has been finalized. So for example, automatically, let's start with this. If you file for divorce, the only thing that changes is the power of attorney is no longer effective. Now, you have to let third parties know that. In other words, just because, right, if you have your money at Bank of America and you file for a divorce, while technically your soon-to-be ex-spouse cannot take money out of the bank, if they bring this old power of attorney to the bank doesn't know that you filed for divorce, and so they can still be a problem, right? So we want to make sure that if you even are thinking about filing for a divorce, that you speak with your estate planning attorney to change all these documents. But what happens is, now keep in mind that let's clarify that filing for divorce can happen on day one, but the divorce might not be finalized for months or even years, okay? While the divorce is pending, there is no change to your will, your trust, pay on death beneficiary designations with life insurance companies or annuity companies. And so what happens is if you pass away while a divorce is pending, your soon-to-be ex-spouse might still get everything if that's who's supposed to get everything as the document's written. You understand what I'm saying? So if you get divorced, they're not entitled to any of that stuff. If divorce is finalized, it's as if the will and the trust treats them as if they've predeceased. Your life insurance policies won't pay out to them. It treats them as if they've predeceased. Annuities won't pay out to them. They're treated as if they predeceased. But what happens if you pass away while the divorce is pending? Then the person who, maybe the one person you don't want to get everything, gets everything. So if you're thinking about an important life event like a divorce, you want to speak to an estate after you call your family law attorney, you want to speak to an estate planning attorney. Very, very important. Now, let's talk about other important life events. If you're going to get married, yes, you want to update your will, you want to update your trust, you want to update your powers of attorney and your healthcare surrogate designations. And if you have new children, even though you may not necessarily have to, meaning your will probably already says the children I have now and any children born thereafter, but it's best practice. You want them named. If you have a new child coming or on the way, you want that person contemplated in all of your estate planning documents. So yeah, very important to meet with an estate planning attorney before any of these major life events. A marriage, a death in the family, and divorce is the big one because, again, starting a divorce and actually following through and getting that final divorce, a lot can happen in between there.
A lot.
Yes.
Wow. I didn't know that they can just have all your stuff after,
Yeah.
if you don't complete
Yeah.
the modifications. Wow. Whew. How can people include digital assets such as cryptocurrency or online accounts in their estate planning?
Yes, so it depends on the type of online account, but cryptocurrency is the trickiest one. So because those are typically in wallets that have, I forget what they're called, but they're just numbers. There's account numbers. There's an account. There's a wallet number and a wallet password and a special identifying code. And for those, really right now, the best you can do is make sure that you have that information securely written down somewhere where it can only be discovered after you pass away. So maybe a safe deposit box or something like that, so that obviously if you don't want to give someone access to it before you pass away because then they can abuse it. As far as online accounts, increasingly what we're seeing, like even things like Facebook, we're seeing the ability to go into the account. You can designate essentially someone who can access the account after you pass away. So you want to that's going to vary depending on what online account you're talking about, whether or not. So either you're writing down the password, where similar to the cryptocurrency, where it can only be accessed upon your demise, or you can go some online accounts, depending on who it's with, will have the ability to designate someone who can indicate that you passed away, prove that you passed away with maybe a death certificate, and then access that online account. So a little trickier when it's online.
Okay. Wow. I didn't think you could actually put cryptocurrency in a trust, but
Yeah.
that's pretty cool.
Yeah.
What legal strategies can help individuals qualify for Medicaid while preserving family assets?
Yeah, so that's a lot of what we do. I've written a book about that, and it's available on Amazon. And it's called How to Get Medicaid to Pay for Some or All of Your Long-Term Care Expenses Without Having to Sell Your House, without having to wait 5 years, without having to go broke first. And the idea is people come to me because they have too much by way of income, they have too much by way of assets, they would rather not have to spend it all in order to qualify for Medicaid benefits to pay for. The programs I work with are long-term care oriented. So there are people who need help paying for home health care, assisted living facility care, or nursing home care. A lot of people, when they hear Medicaid, they think nursing home. That's the most popular of the long-term care programs. Most of my clients do not want to be in a nursing home. Most of my clients want to stay at home for as long as possible, or be in an assisted living facility, which is a homier-like setting. So for those people, it depends on how much money they have. It depends on meaning it depends on what we're protecting. So the strategies that I use to protect someone with an excess of $25,000 is different than the strategies I use to protect someone who has an extra $600,000. So the first thing to keep in mind that a lot of people don't realize is Medicaid does not look at everything that you own when determining whether you are or are not eligible. There are certain assets like your house, like your car, like pre-need burial insurance, right? So that's, by the way, what you do, Kattt, is so important to both the estate planning and the Medicaid planning world. Estate planning is, of course, what's gonna happen to you after you pass away. Making sure you have that taken care of beforehand is a huge bonus for the surviving spouse, for the children, because they're mourning. And why not give them one less thing to worry about? So I think what you do is a beautiful service and really, really important and impactful for families and should be a part of everybody's estate planning. On the Medicaid planning side, it's particularly useful as well because it's a valid way to spend someone's money. So while typically we're in the business of getting money out of someone's name in a Medicaid compliant manner so they don't have to wait 5 years. One thing you're able to do is you can really buy anything you need or want. So again, we don't want to be wasteful, but if they have not prepaid for their burial or cremation or whatever their final arrangements are going to be, my first thought is, well, someone's going to have to pay for that at some point in time. While we're getting money out of your name, we might as well go purchase a policy or make those pre-need arrangements because they don't count against you when determining whether you are or are not eligible for Medicaid as long as it's irrevocable. In other words, you could have a New Orleans style funeral with a marching band behind the casket, and that could be $30,000, $40,000. As long as it's pre-need, prepaid for irrevocably, that's okay. Of course, most people don't do that, of course, but I like to illustrate that you can get whatever you want. Prepay for the memorial service, prepay for the priest, the reverend, the minister, the rabbi, the imam, whoever it's going to be, prepay for it and get that out of the way so your family doesn't have to worry about it. So now, once we're done spending money and once we're done not worrying about the house or worrying about the car, we may want to do estate plan to avoid probate for those things, right? With the house, we'd prefer to not have to go through probate, save the family time, money, and expense. But when it comes time to, once we're beyond all that, we still have $25, $50, $100, $200, $300,000, whatever the case might be, then we're doing things like talking about special needs trusts. We're talking about things like personal services contracts where you can prepay family members to take care of you. There's something called a Medicaid compliant annuity. There are promissory notes. We have all sorts of different strategies, and everyone's going to be a little bit different. But the good news is everything we do is Medicaid compliant, meaning I'm not hiding money from anybody. I'm telling the government, my client started out with $200,000 or whatever the case is. Now they have $2,000. Here's what we did with the money, and here's the corresponding state and federal law that says what we did was okay, and you, state of Florida, should not penalize my client and do not delay their benefits. And now we're getting them staying at home longer or helping them pay for expensive facilities. And it also pays for great health insurance and co-pays and prescriptions and things like that.
What protections are in place to prevent elder financial abuse, and how can families assure their loved ones are safeguarded?
Yeah, so this is where I like to talk about perhaps the most important planning document I can provide one of my clients. I do all sorts of fancy trusts and complicated planning, but there's no better planning document I can provide than a well-drafted, durable power of attorney. Because if you do not have that in place and you lose your ability to make decisions for yourself, you are leaving it up to maybe a court or maybe someone who's not so scrupulous to try to take advantage of what's going on with you. Okay? So we want to make sure that while you have your mind, we're able to get a power of attorney in place where you are choosing who's in charge. Beyond that, sometimes we're also talking about irrevocable trusts, because I had a client that I just spoke to that's about 1 or 2 months ago. And she came to me and said, I don't trust myself. She recognized that I'm impressionable, and if someone comes to me and asks me to donate money, I'm going to donate money, and I'm worried about, and my kids are worried about being taken advantage of. So for those people, for this particular lady, we put all of her assets into an irrevocable trust where her kids, who she trusted above all else to take care of her, her daughter, one particular family member, to be her trustee. So she literally didn't have, even though the trust was for her benefit, she didn't have direct access. So it wouldn't matter if someone came to her and said, here, sign this check for sign your deed over to me, or give me access to your bank account. She would not have been able to access it anyway because she's already empowered somebody else to take care of her. So these are some of the things that we think about for people who are subject to elder abuse. And ultimately, nothing's foolproof. Nothing is 100%. So sometimes we have to get the Department of Elder Affairs and Adult Protective Services involved, and those are, of course, sad stories.
Let's switch gears and talk about wrongful death.
Yeah.
So what types of damages can families seek in a wrongful death claim, including non-economic damages like emotional distress?
Yeah, so it depends. So let me just say that so I'm actually a lawyer who's a partner in 2 different law firms.
Oh, okay.
So I am the managing partner, spend most of my time with a firm called Elder Needs Law.
Okay.
elderneedslaw.com. So that's where I spend most of my time. My background is so I've been doing that for maybe about 10 years. But before that, I spent time as a personal injury lawyer, and it happens to be a firm that was started by my father, and he is the managing partner, still is the managing partner of that law firm. And as I got into elder law, my partners in the personal injury firm said, hey, maybe go start another law firm because we like only doing personal injury here. So now I have my foot in both firms. So my father's Alan Neufeld, and our litigation, medical malpractice, wrongful death genius attorney is a gentleman named David Kleinberg. And I actually think he'd make a great guest on your show because he can talk about wrongful death all day long. But generally speaking, what I can tell you, there's a number of factors that go into it. So for example, did the person who passed away due to wrongful death, was that individual the wage earner of the family? And did they have children who were still dependent on him or her? Or were they married at the time? So those are the people who are going to have because if you have, I remember we represented the family of a gentleman who was early 50s when he passed away, was a high wage earner, and so we were able to calculate out, until he turned 65, what the family lost. So there's lost not only current lost wages, but future lost wages, and loss of consortium, and loss of love, and pain and suffering. And so there's absolutely a lot of damages. But I want to not make. I haven't practiced wrongful death myself in a long time. I think of David Kleinberg.
So we'll go back.
Yeah, I think David Kleinberg is hilarious, and he's fantastic, and he's a genius, and would be a great guest for the show.
Okay, so let's go back to estate planning. All right, cool. All right, so how can estate planning help blended families manage inheritance fairly and avoid disputes?
Yeah, so this is where, so for folks who don't know, blended family refers to when you have a married couple. It's typically not their first marriage, and they'll have children from separate relationships. Typically, just to compare and contrast, if I have a married couple and they have all the same children and we're doing estate planning, we'll typically have a joint revocable trust. In other words, one trust for both spouses. When I have a blended family, I typically want each spouse to have their own trust because they get to decide who gets what after they pass away. Now, you're not allowed to completely disinherit the spouse unless there's a prenuptial agreement or they agree to that. So we have to talk about, are you disinheriting the spouse? If so, we have additional paperwork. We have to make sure we get in place for that. And if not, let's make sure that, what do we do to make sure that that spouse is treated fairly and your children are treated fairly? So we can the nice thing about trusts is they are almost infinitely malleable. So if you can dream it, we can make it happen for the most part.
Okay, good. Man, we're coming down to the final stretch. I wish I could ask you.
Oh my God, it goes so quickly.
It goes so quickly, and I'm trying to decide which question to ask you. Okay, can you explain quickly special needs trusts and how they support individuals with disabilities while preserving their eligibility for government benefits?
Yeah. Oh, this is such an important topic. So the typical scenario is we have healthy parents and they have a disabled child, and that they may have other children who are not disabled, and they don't. The instinct is they know they want that disabled child to qualify for Social Security benefits early. They want them to qualify for Medicaid, perhaps long-term care Medicaid, to pay for home care or facility care, depending on the nature of the disability. Their instinct, unfortunately, sometimes is to completely disinherit them and give all the money to another healthier child and say, make sure you take care of your disabled brother or sister. That might work, that might not work. The problem is that what if that person dies? Well, now whatever their estate plan says is what will happen to that money. So that's not the smart way of doing it. The smart way of doing it is you want from the parents' revocable trust. You want whatever share they want going to the healthy child to go straight out to the healthy child, and that's perfectly fine. Whatever they want to go to the disabled child should, instead of going to the healthy child, instead of going directly to the disabled child to prevent them from qualifying from benefits, it should instead go into a special needs trust, which has, under state and federal law, has a special designation that says any amount of money going into this trust does not count as a resource or an asset when determining whether or not the disabled individual is or is not eligible. And because it was never their money to begin with, if there's still money left in the trust when the disabled child passes away, there is zero Medicaid payback obligation. So it can just, you make sure that the disabled child always has access to money, and it's going to improve the quality of their life. And if there's money left in the trust when they pass away, it goes to the healthier child or wherever it is you want it to go after they pass away in a way where Medicaid can't touch it. So you get to have your cake and eat it too. So and there's all sorts of different types of special needs trusts, and I could talk more about it if you want, but I think we have a time issue. But special needs trusts we could talk an hour just about special needs trusts. It's a topic near and dear to my heart, and I love talking about it because it's very, very important.
Good to know. Okay. What are the? My final question is: are there any latest legislative changes affecting estate and elder law that families should be prepared for actually 2025?
Yeah, 2025. Yeah. So, well, first we're not sure. So we expect, because we have a Republican president coming into office and a Republican-controlled Congress, we expect the estate tax to remain, the estate tax exemption to remain as high as it is. Mm-hmm. Otherwise, it's supposed to sunset, meaning it's supposed to go down to a much smaller number, but we're not, most estate planners are not worried about that because Republicans typically keep that high. Not in 2025. We don't know what's coming up for 2025, but interesting, in 2026, for your listeners who have disabilities, who have disabled children, they should know about an ABLE account, which is a special type of account that can grow tax-free. Currently, the law says that you can't participate with an ABLE account unless your disability started before you turned 26 years old, so 25 or younger. But in January 1st, 2026, that law is going to change. President Biden signed the law that will increase that age to 46. So for people, what's interesting about that is money can go into an ABLE account up to a certain amount every year, but the money in that account grows tax-free, like a 401k or an IRA or a 529 account. The money can be accessed by the disabled individual themselves to pay for almost anything that they need. It can be invested conservatively or aggressively, and it doesn't count against them when determining whether or not they're eligible for Social Security, SSI, or Medicaid benefits. So it's a really wonderful benefit that we're excited to see for our disabled community.
Nice. So you actually finished right on the dot, Jason. I want to say thank you to our listeners. Jason, really quickly, if our listeners wanted to get in touch with you for any of the things that you discussed this evening, how could they reach you?
Great ways to submit a form on our website. That's elderneedslaw.com. If they're interested in just learning more, I have a very productive YouTube channel, which is just YouTube, and then type in Elder Needs Law in youtube.com/@elderneedslaw, and I'm giving out free information, practical advice, and they can email scheduling@elderneedslaw.com. So any way they want to get a hold of me, I'm happy to help.
Perfect. Thank you so much, Jason, for being on the show. I really appreciate you immensely. Listeners, thank you for joining us at 6 o'clock. And I wish you guys, this is actually the week before Christmas. So if I don't get to say it to you guys, Merry, Merry, Merry Christmas. Happy holidays to everyone. Be safe, and we will see you next week. You're listening to WSRF 1580 AM, 99.5 FM, and also YouTube and Facebook. See you guys later. Bye.